We are now recording. Lila, would you like to introduce the meeting or would you like me to?
Please introduce the meeting.
Okay. This is the December 22nd, 2020 Compliance and Amendments Committee of the Sunshine Ordinance Task Force. The time is 4:43 p.m. Shall I call the roll?
Yes, please.
Member Wolf. Member Wolf. Member Wong.
Present.
Member Wong.
I think
present.
Member Wolf stepped away for a second.
All right, let's hold off on the roll call.
Thank you.
Hello, can you hear me?
Yes, we can hear you.
Okay. You may not be able to see me, though. Something wrong with my camera. But I'm here.
Let's begin with roll call again. Member Wolf?
Yes, here.
Member Wolf present. Member Wong?
Present.
Member Wong present. Chair LaHood?
Present.
Chair LaHood present. We have a quorum.
Thank you.
Are there any agenda changes that anyone wants to make or discuss?
I don't think so, unless any members, any other agenda changes.
Nothing for me. This is Member Wong.
All right. Let me read the preamble.
Thank you.
Remote access to information and participation. In accordance with Governor Newsom's Executive Order Number N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via video conference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. The Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/suntime. Excuse me. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Thank you. I'll read meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Cheryl, please call the next item.
What I do want to do is call item 1, call to order roll call and agenda changes, discussion regarding the number of complaints filed by anonymous scheduled for this hearing. So that's the subject matter we need to address. considering the rule of the complaint committee in the complaint procedures that one petitioner, one respondent can only have 2 matters heard before a committee. This one has about 5, and I think this is a subject matter that we need to address.
So I believe, and Bruce, correct me if I'm wrong, but I believe we had a conversation about this before, that is our rule. And because it is our rule, we can choose to, for management of cases and to group together cases, that we can choose to add more. Is that correct? Is that how we intend to use this rule? Bruce, are you there?
He dropped out again. He needs to rejoin.
Chair LaHood?
Yes.
It's my understanding that if the chair and the committee believes that they are associated files with the agreements of both parties, you can combine them into one hearing.
I don't think this was so much about combining complaints into, which I know what I understand what you're referring to about combining the complaints. This was about having for uncombined complaints, having more than 2 for a petitioner at one hearing. Cheryl, is that what you were asking about?
Yes. They have, as had been discussed in November with all the chairs and this particular requester, they had similar subject matter. And so that's why this particular requester and Chair Wolf and you guys discussed which matters could be heard due to what the subject matter was. And so that's why I grouped these particular cases together.
Yes, and I believe it was in that conversation, and perhaps Member Wong recalls or has, Member Wong, do you recall that we also brought in that discussion about scheduling, had a conversation about our rule regarding 2 cases per petitioner, and Chair Wolf, Member Wolf, had said, well, it's our rule, and because it's our rule for managing cases, because this would allow us to address a larger number of cases quickly, that this is something that we could choose to do. And I hope he's able to get on.
That is correct. It is a rule created by the task force themselves, and you can waive that since it is your own rule.
Okay.
And
so
there's
in
no
that case,
function or action needed to waive it. Just noting it will be fine, and you can, just them being on the agenda, you have already acknowledged that it is acceptable.
okay, thank you.
I do want to say one thing, that these particular matters were discussed with the petitioner and the chairs, and that they involve police misconduct and First Amendment coalition issues. So that's why they were grouped together the way they were.
You mean First Amendment issues, not
yes,
First. Yeah.
Yes, First Amendment, I'm sorry. And it was agreed during this meeting that these cases would be heard before CAC, compliance and amendments. So that's what I have in my notes from that particular meeting. So.
Okay. Is Bruce back with us, or are we still waiting for him?
I'm not hearing anything, Lila.
Okay.
But let me just. Do you want to wait, or do you want to proceed with approval of the minutes, public, one of the cases? How would you like to proceed? Do you want to wait?
So he dropped out. We haven't heard anything from him. Let's give him 1 more minute, and then if not, we'll proceed with approval of the minutes and public comment.
Okay. Yeah, public comment can happen pretty quickly.
Can I ask that all the participants by phone please mute yourself by pressing *6?
Okay, I think that we should proceed with the next item with unless, do we need to take public comment on our waiving of the rules?
We probably should.
Why don't we take public comment on that?
Okay.
Is there any public comment on the committee's decision to waive its own rule in allowing more than 2 complaints to be heard in the same meeting by the same complainant?
Yes, I have a comment.
Please go ahead.
Hello.
Go
Thank
ahead,
you.
speaker.
Hi, this is Anonymous, and thank you. This is Anonymous, the person whose complaints you will be hearing. So what you asked me, and this is an email, you asked me to identify the topics of all of my remaining complaints. I did so, and that is where this agenda, I presume, comes from, related to SB 1421. Thank you very much.
Thank you. Is there any additional public comment on this issue? Hearing no further public comment, let's move on to the next agenda item.
Item number 2, approval of the November 24, 2020 Compliance and Amendments Committee meeting minutes. Anybody have any changes or additions?
Nothing from me.
Nothing from me. Let's take public, or wait, do we have a motion to approve the minutes?
I will make a motion to approve the minutes.
And since I am the other person here, I will second the motion, and then we can take public comment on the minutes.
Yes, please.
Okay, Cheryl, are you ready?
Go ahead, speaker. Hello?
So last month's audio remains unavailable for anyone. Yes. So last month's audio remains unavailable, so it's not like the members of the public can't really verify the minutes against the audio, and that's the case for this meeting. But also in these minutes that you're approving, you state that approval of October 2020's minutes would happen today. It's not happening, so please do remember to make sure that you approve October 2020's minutes at some point, because at the last approval of minutes, two other complainants said that you hadn't properly documented their complaints, and so you continued the approval of October to a later time. Thank you.
Thank you. Is there any additional public comment on the minutes? Hearing none, Cheryl, I'd like to ask that we make sure we include the updated October minutes in the agenda packet for the January CAC meeting so that we can approve them at that time.
Okay. Just making a note to do that.
Thank you.
Yeah. As far as the November hearing not being provided on the web, I noticed that myself, and I don't know why it hasn't been provided, because I believe I sent it to our IT person, but I'm going to check with that person tomorrow morning, find out what's going on, because it should have been uploaded. So.
And actually, let me ask Member Wong, do you think we should hold off on approving these minutes until the audio is available and then approve both October and November in January?
Yeah, that might be a better idea.
Okay.
I'll rescind my motion then.
I will rescind my motion as well. And it looks like we have Member Wolf back with us again.
Can you hear me?
Yes, we can hear you. You're a little bit quiet, but we can hear you.
Okay, thank you.
Just to give you an update, we currently don't have a motion on the table regarding the minutes because the audio is not yet available. And we also need to include the updated October minutes. We need to include the updated October minutes in the next agenda packet. We're going to hold off on approving these minutes until our next meeting because the audio is not available.
How long has it been? A month?
Yeah, and I mean, I have a record of sending it to my IT person, but I don't know why I have an echo. Hello? Can you hear me now?
That's better.
We can hear you.
Okay. Yeah, so I'm going to check on that in the morning. I'll find out what the story is.
So the minutes aren't posted on the website yet?
No, the minutes were posted.
I mean the audio?
It's the audio, yeah, and I don't know why. So. What is that background noise?
Unless there's any other discussion of this matter, I'm going to suggest, since we don't have a motion on this, and we'll continue with approval of the minutes for the next meeting. So let's move on to the next item.
Do you guys hear that buzzing noise?
Yeah.
I think it might be viewers. I'm not sure.
Let me mute.
Yeah,
I think that's better.
That. Yeah.
Yeah, that's better.
Just having awful problems with Microsoft Teams.
Yeah, I'm getting the same buzz though.
Do you have headphones?
I have earphones that I use all the time that don't cost
try it.
phones.
Oh, I meant Member
Bruce?
Wolf actually. So yeah. Technology.
So in the meantime, let's move on to the next item, please.
All right. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Do we have any members of the public wishing to comment on items not on today's agenda?
Is that better?
No?
Yes.
Yes, please.
Okay.
Okay, it sounds. I heard one member of the public. Cheryl, are you ready with the
Sorry?
timer?
Yeah, I'm ready. Speaker?
Okay.
Speaker?
All right. Thank you very much, members. So Member Schmidt mentioned a new ruling since your last metadata case. He's absolutely right. This May, while SOTF was off for COVID, the Supreme Court ruled in National Lawyers Guild versus City of Hayward that even under the weaker CPRA, without the sunshine enhancements, redaction of electronic data is not a creation of a new record, and it's not one of the computer services under CPRA that are optional. And that work has to be done for free to everyone in California. It doesn't matter how hard it is. It doesn't matter how expensive it is. And this applies much broader than the metadata rulings that I want this committee to rule for compliance, I believe, shortly in 19044 and 19047. I think it's a fantastic ruling by the Supreme Court. I'm sure governments don't like it, but it's a really great ruling, and I'm really looking forward to having 19044 and 19047 be heard before this compliance committee. Yesterday, the Department of Public Works released a record that mentioned the mayor's phone number, and I informed them that they had done so, and Breed's office issued various takedowns today. Now compare this to Dennis Herrera's office, who I informed them in July that they had released the driver's license number and other personally identifying information for Brian Carmody. And I told them in July, and they haven't even replied to me. And I think this really reflects the difference in how the government treats other members of the government, other city employees, versus how they treat the public. It's not just a violation of, this is not a violation of my rights under Sunshine. It's a potential violation of the rights of other people under their personal privacy rights. And it should really be treated the same way. You should treat the personal privacy concerns of whether you're a city employee or a member of the public, in this case, a legal opponent of the city, you should be treated fairly in all circumstances. And finally, I would ask that this committee allow, like the Board of Supervisors does, parties, both the complainants and respondents, to join via Teams. It would make it much easier to give you presentations. It just would make things smoother. Thank you very much.
You're muted, Lila.
Thank you.
Sure,
Thank you for your comment. Do we have any other members of the public who would like to make comment on matters not on today's agenda? Hearing none, let's call the next item.
Before we go, can I just make a comment on the public speaker?
Yes, please.
So on the first point regarding what Member Schmidt had reported, I seem to recall the task force had already been down that road. We had already have at least one determination with regards to whether edits or like excerpts of various videos would be the creation of a new document or not, and whether that's covered under Sunshine, and the task force had ruled that it is prior to this case law. So I'll try to dig that out. It's been a number of years, but I think we've already, something like that has already come before us. A lot of it happened during the time that drones were being purchased by all kinds of departments, and then the police cameras, body cams, were instituted. So that was those issues around that. And then there was another point that I want to make. I don't recall. Okay, thank you.
Thank you. I don't think we had any further public comment at my last call, so let's move on to the next item, please.
Item number 4, file number 19124, complaint filed by Anonymous against Chief William Scott, Lieutenant R. Andrew Cox in the Police Department for allegedly violating Administrative Code Section 6721, 25, 26, 27 by failing to assist in a timely and or complete manner, by failing to provide a timely or complete response to records requests, by failing to provide rolling responses, by failing to withhold the minimal portion of public records, and by failing to provide written justification for withholding. This is the first time this complaint has been heard.
Thank you. And to be clear, for those who may be listening, we're meeting today to determine whether there is jurisdiction, and if so, to make sure that we have all of the information we need regarding this complaint. Do we have both the petitioner and the respondent in attendance?
Petitioner is present.
Lieutenant Cox of the San Francisco Police Department.
Okay, thank you. We will hear first from the petitioner, and you'll have 5 minutes.
So are you ready?
Thank you very much. Yes. Thank you very much. We'll begin on page 250. We will begin on page 256 of the PDF, which is footer page P264. So this is one of two SB 1421 complaints against the police department, and this is all of the SB 1421 records from 2019 and the communications about those records with requesters. There's a simple thing, which is that nothing was produced until after I filed a complaint, and that was a failure to provide a rolling response. But that's not the interesting part here. The interesting part for the rest of the issue, which is they did not provide a timely statement of quantity, nature, or existence or form of record. They did not see by footnote or other clear reference their redactions, and they unlawfully used an exemption, Government Code 6254F, which is not allowed in SB 1421 records. So at the bottom of this page, you'll see the second slide. I don't think there's much for me to explain here. You've held this in my cases, in many other people's cases. It's literally the words in the law. They have to provide a key by footnote or other clear reference. I think the issue here might be this is just an older complaint. SSPD has accepted this responsibility in all of the other complaints. They normally provide very detailed logs of exactly which redactions what. I hope they do so here. And I would like to remind you, in a prior complaint, SOTF 19121, the police commission said, well, they didn't give us these keys by redaction or footnote. And the problem was, I challenged, I think, maybe 50 or 40 of them, and dozens of them they admitted are wrong. And this is possible because when you don't key your redactions, you don't justify your redactions, you're sloppy. You don't have to give a legal reason. I don't think I need to explain more here, but SB 1421 records are some of the most controversial records that exist in the city. They're some of the most important to justify. Next page. The supervisor of records. Somebody is speaking. Please be muted. The identity of requesters.
Point of order. Can we just stop the clock, please? Madam Chair, can you please have whoever's managing the microphones to mute the meeting to mute everybody?
Yes.
And then we'll have just the parties unmute themselves. Thank you.
So has that been taken care of?
Okay, I have muted all of the callers. If you are part of this hearing, please press *6 to unmute yourself.
Thank you, Victor.
Okay. This is complainant. May I continue?
Yes, go ahead, sir.
Yes.
Thank you. So we're on the second page, 257. So the supervisor of records has already ruled in this particular request that the, quote, identity of requesters is not private. For whatever reason, Herrera refused to issue the order, right? Once he determines that there's something not private, he's supposed to issue an order. It hasn't been issued. I have no idea why this information is redacted. And Government Code 6254F is not allowed in SB 1421. SB 1421 starts right there, notwithstanding Subdivision A of Penal Code 832.7, which is the police personnel exemption, or Subdivision F of Section 6254 of the Government Code, or any other law. Those records shall not be confidential. So 6254F cannot be used in this case. If you look at the next page, these are just some examples. They're just two random pages of the records. There's no way to know why any particular redaction was made. And I actually don't think in this particular case I need to prove anything at the committee level. These are obviously public records. There's no dispute about that. You obviously have jurisdiction. If you look at the final page, the next page, you see my schematic guide to what I believe SB 1421 does, right? Every record about the conduct of public business is completely disclosable by default under CPRA. But 832.7a made all the peace officer personnel records completely exempt. And then 832.7b1, which is SB 1421, made an exception to that exception, which makes them public again. And there's 4 types of mandatory redactions. They're on the left-hand side: personal info of officers, anonymity of complainants' witnesses, federal law prohibitions, invasion of personal privacy, or a danger to safety. And then there's one optional, it's in a different portion, an optional statewide redaction, which is the public interest balancing test. I actually don't think SSPD has used the public interest balancing test, so I'm not going to go into it on this case. but I think it's pretty simple. They need to give the footnotes or other clear references, and they should not be redacting 6254F material, which is police investigatory material, when it's in an SB 1421 record. Let me see if I have anything else to say. Oh, and the identity of the requesters should also be undisclosed. Again, I don't think I have to prove anything at this hearing other than the records are public records, which they obviously are. That's it. Thank you very much.
Thank you. Is the respondent ready?
Hang on.
Yes. Whenever you are.
Okay. Cheryl will give you the green light.
Got it.
Go ahead, sir.
So good evening, everyone. As you know, this is kind of an older one. It's over a year old, as Anonymous has already stated. SFPD took full responsibility of some of the things he actually didn't go over, the not providing a response in a required time frame. This is one of those old cases where Anonymous had sent it to an email address that hadn't been monitored, that has been rectified. Let's see what else we got. We admit obviously because we didn't respond to it within 24 hours, we did not respond as this wasn't an IDR we just didn't respond to it as an IDR. We accept that. What I'd like to say about the redactions, and I think Anonymous just said it too, is because this is early in the process, there were a lot of there's a lot of growing pains. And as of now, with our SB 1421 units, the appropriate keys are being made available, or footnotes. So this case will, if it hasn't already been, or the cases that were presented to Anonymous in this PRA, will be reissued with the correct redactions. And I think that's all I have for now. Thank you.
Thank you. Members, do we have any questions for the petitioner or the respondent?
This is Member Wong. So this is primarily just a question for the respondent, Lieutenant Cox. I was just wondering about like a time frame for actually getting those documents over to the petitioner then, if you have one.
I believe maybe, oh, sorry, didn't mean to. And maybe Anonymous could help me out in this one. I know that most of these were sent to the supervisor of records, and I believe Lieutenant Walland has been working with them to get this to you. Is that correct?
Would Member Wong like me to speak here or no?
The chair will allow the petitioner to respond to the question from the respondent.
Thank you. No, actually, I believe I know who you're talking about, but Lieutenant Whalen, I apologize, I don't know how to pronounce her name, has not given me anything new. I'm happy to talk to you guys offline about when I can start expecting those redactions and keys. So.
Okay, I apologize. I thought that the supervisor of records was working with her in that aspect, but that is definitely, as you said, something offline I can discuss with her and get a status.
Member Wong, do you have a follow-up question?
No, I do not.
Okay.
And just, if I may, and I know everybody's kind of in a bind right now, but these are extremely labor-intensive files. I wish we had more of a staff in our unit to do it. So it is taking time, and I apologize. I know it's important for these documents to be released to the public in a correct fashion. Like I said, we're having we're still having, growing pains after a year, but with COVID and having people telecommute, but these things are voluminous, so we're trying.
Thank you. Members, do we have any additional questions, or would we like to discuss things amongst ourselves?
Actually, may I say something?
One moment. Bruce, I'm not sure if you were saying something. I think you're on mute.
No, I wasn't. I was
Okay, it was not.
talking to myself.
Sure. Petitioner, yes, what would you like to say?
There are two SB 1421 complaints against the police department. It may make their life easier, my life easier, your life easier to combine those. I can give you the file number, and then you can do whatever you want in the motion, but I would suggest finding the jurisdiction, finding these records are public, but then allowing maybe another committee to hear the file number 20053 to allow them, if the police department consents, to combine them. There's just no need for two complaints, right? So,
Madam Chair.
Yes.
So I think that's a good idea, but there's no necessity for a different committee to hear it. It's actually preferable for this committee to hear it, as would be the one to recommend the combining, so that there's some common knowledge between the two cases. Having it split between two different committees really confuses the issue. We've had this happen before. Usually when we want to consider combining, we send all those cases to the same committee.
I agree. I think that makes sense. So it might mean, well, first, let's decide what we're going to do in this case, and then we can determine if it would make sense to combine those before sending them to the full task force.
Okay.
So committee members, do we have any other questions, or are we ready to discuss? Are we ready to find jurisdiction here?
Yeah, I'll move to find that the records are public and they are within our jurisdiction, and to recommend it for hearing at the full task force.
Do we have a second?
I will second that motion.
Is there any public comment on this motion by members of the public who are not parties to the case? Hearing no public comment, and I'm going to give it one more minute because I know everyone, not a minute, but I know everyone was muted. If you need to unmute yourself to make public comment, we're ready to hear you, but if there's no public comment, we will call roll. Hearing no public comment, please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye. The motion
Chair
passes.
LaHood?
Yep.
The motion to send to the full task force passes.
Thank you. Please call the next item.
Item number 5, file number 1. Excuse me, sorry. File number 19144, complaint filed by Anonymous against the Department of Police Accountability, Paul Henderson, Diana Rosenstein, Stephanie Wargo Wilson, Mary Polk, for allegedly violating Administrative Code Section 6721, 24, 26, 27, by failing to respond to a public records request in a timely and or complete manner, failing to assist in a timely and complete manner, failing to cite lawful justification or exemption, failing to key redactions or footnotes or other clear references to justifications, and failing to withhold the minimum portion of records.
Thank you. Do we have the petitioner and respondent for this file in attendance?
Petitioner is present.
Newton Oldfather for the DPA.
Okay, thank you both for being here. We'll hear from the petitioner first. You have 5 minutes.
Hang on.
Just hopefully everyone's muted again.
Are you ready, sir?
I am. May I begin?
Okay. You may
Thank you
begin.
very much. Thank you. This is Anonymous versus the Department of Police Accountability. Very similar case. We're going to begin on page 123 of the PDF, which is footer page P429. This is, to me, the most important of all of the cases today, mostly because the DPA, unlike other people, they don't comply after you talk to them. They just refuse to comply with most of these provisions of the Sunshine Ordinance. Again, I requested the SB 1421 records. There is no timely statement. At the time of the complaint, they wouldn't even give me any written justification for withholding. They now produce these blanket cover letters for every single record they produce, with all possible justifications. You can't do that. There are no keys by footnote or other clear reference for redaction. There's something more interesting here, is they're not going to produce audio or video records unless I pay for their production. As I just mentioned, National Lawyer Guild versus City of Hayward, that's illegal not just under the Sunshine Ordinance, but even under the CPRA. They have to produce the audio-video records. They have to redact them correctly. They cannot use the public interest balancing test. On the bottom here, you'll see their argument is, it's like as if I'm a member of the police union, I have to do a meet and confer on these redactions. Absolutely not. You should not read into the law made up things that the DPA wants to argue. This is not what the law requires. They say, well, the police commission has created this process. I don't think they understand the police commission's own SB 1421 records are redacted meticulously. And I do have to say good job to the police commission. Each and every word and phrase has a number that identifies what is redacted at the police commission, but the DPA just refuses to follow this law. Next page, the expense or effort required to redact an audio recording is not an exemption. It's not an exemption under 6726, which specifically says you cannot charge me personnel costs. It specifically says you have to mask or redact the exempt portions. They claim that if they give me a transcript that's a separate kind of record, that constitutes a copy. Would you ever argue that you could say instead of a body cam footage, you could give me a narrative of what happened? Absolutely not. SFPD gives me body cam footage with meticulous redactions. There's no reason that DPA is not required to give redacted properly records. And it's not just under Sunshine, under 6926, it's also under the case I just cited, National Lawyers Guild versus City of Hayward. The most interesting thing here at the bottom here is they claim the ability to use Penal Code 832.7b6, which is an optional redaction that is the public interest balancing test. Mr. Oldfather, he is an attorney. As an attorney, he's held to a higher standard than me or normal people who come before you. You're an administrative tribunal. Mr. Oldfather is not allowed to misstate what the law is to this tribunal. He has told you that SB 1421 states that the public interest balancing test should be applied. Absolutely not. It says may redact. And then he says, accordingly, the DPA is obligated to apply the rule if applicable. This is a lie. That is not what Penal Code 832.7b6 says. I would ask you to ask him to retract this false statement of law. This is not how you should win. You should win honorably. This law is different than the other redactions under SB 1421, which are mandatory. The Sunshine Ordinance cannot abrogate the other exemptions, but B6 is an optional exemption, and the Sunshine Ordinance abrogates that exemption under SF Administrative Code 67.24I. If you look at the next page, these are the pages. There's no way for me to know why a particular sentence is redacted or a particular paragraph is redacted. I don't have to guess. You have held this many, many times. There is no reason DPA should not be held to the same exact standard as every other agency. All of these redactions should be keyed. This is built-in features of Adobe Acrobat or NextRequest, which is what they're using now. They claim that it's a lot of work to add these later on. That's not how you redact a record. If you read 6726, it's the personal responsibility of the person redacting the records to give you those footnotes or clear references. While they're doing the redaction, they should say, this redaction, thank you, this redaction is for this reason. And that makes it much more likely that they're actually redacting lawful information instead of redacting whatever they want. These records are obviously public records by definition, so I don't think I have to prove anything else at the committee level. Again, this is the most important of these cases because DPA just is violating all sorts of provisions of the Sunshine Ordinance. Thank you very much.
Thank you. Is the respondent ready?
Yes, good evening. My name is Newton Oldfather. I'm a representative of the DPA. My understanding is that this hearing is for jurisdiction only, and the commission or the committee is not interested in any substantive argument on the merits of the complaint. Is that correct?
That is correct, but we want to make sure that we have all the information we need before sending the case to the full committee. So that's why we're hearing from the petitioner and the respondent.
Okay, great. I just want to take the opportunity to provide a little context for the DPA's response to these records. When 1421 first passed, we received a number of urgent requests immediately, the day after the law went into effect, from the Public Defender's Office and the ACLU and other news organizations who wanted various files related to officer-involved shootings and a couple ongoing criminal cases that were happening that they needed the records immediately. So we took the time to grab these records, redact them as we're required to do under 832.7, and produce them immediately to get those to the people as fast as we could. After that initial kind of response, we started taking records and sending cover letters to each requester that listed out all the various reasons we have redacted a record, including all the required reasons under 832.7, and all, including like witness information, you know, somebody's birthday, stuff like that. And also to the extent that there was some kind of other redaction, CLETS information, we would cite that in the cover letter. At that point, we were looking at 30 years of DPA complaints, most of which were in paper form, out in storage. And so we decided to make the effort to try to get these records to these interested parties like the ACLU and the Public Defender's Office as quickly as we could, but also providing an avenue for complainants or requesters to, if they wanted to discuss a redaction or I understand where it was or what it was, they could meet and confer with us and say, hey, why is page 47 redacted? What is that? And we could then have a discussion with them about that redaction. That was the best way we felt we could fulfill the purpose of SB 1421, which was to get people, these interested parties, these records, without turning the process into a snail's pace. Which, you know, at this point we have produced over 20,000 pages and with 70,000 redactions. So when you're talking about a redaction law with 70,000 redactions, it's necessarily going to reduce the amount of personnel time and resources we have to produce these records to these parties that need them for criminal cases and for civil rights cases quickly. Finally, we are now using, as the anonymous complainant has said, we're now using this online portal, and we have now the ability to actually do what the complainant has wanted, which is to put little letters on top of the redaction that says PII or something like that, personal identifying information, that will identify for the requester the information that is underneath the redaction. And again, you know, to the extent that they want to know, well, is that an address or is that a phone number? They're of course always invited to meet and confer, and we make ourselves available to any complainant or requester who wants to talk about redactions and challenge them. I've done that personally with the ACLU to discuss redactions, and I know it's happened with other organizations. I've personally extended that to the complainant. He has not taken me up on it. And to the extent that there was two other things I wanted to note. We are, of course, not refusing to produce video unless anyone pays for it. The request in our cover letter informs requesters that a number of these files have 30 body-worn cameras, most of which are relevant to the incident. So we identify them, and we also identify audio recordings, and we provide transcripts at no cost to the complainant or the requesters. And we then say, look through these transcripts, look through these body-worn cameras, see which ones you want, and let us know so that we can spend our resources producing cases to everybody as fast as can, and not just producing 30 irrelevant body-worn cameras to one single person. We want to make sure everyone gets what they need. Finally, as to some of the legal arguments, I can't comment on that. That's a city attorney issue. You have to talk to them about that, about what is appropriate use of a privilege or an exemption under the law. If there's any questions as to how DPA is doing their work, the next redaction, the next production, which will occur about next week,
Good time, sir.
is going to be the. All right. Let me know if you have any questions.
Okay, thank you. Members, do we have questions for the petitioner or the respondent?
I do.
Please go ahead, Member Wolf.
This is for the respondent. You mentioned that there was, in producing all these documents, that there was a redaction log. When you created that redaction log, was it specific enough to cite what each redaction was for? And did you submit it for the record here?
When we submitted records, I submitted a letter brief to the committee. It wasn't clear what records the complainant was referring to or talking about, and I included in my letter brief that if the committee wants to see any particular records, I'll produce them. But I didn't want to dump 11,000 pages of records on you guys.
Why not? We received that
11,
before.
If that's what you guys want to do, I'm happy to produce those records to you.
Well, let me ask you: if a court requested it, would you provide it to the court?
Absolutely. What the production that we have already made to everybody?
Yeah.
You're talking about the full 11,000 pages that at the time of the complaint we had produced?
Yeah. If this was being challenged in court, would you provide it to the court?
I would if they requested it. You can't. I would never dump 11,000 pages on the court at one time. They would not be happy about that. But I would do it if they said that was okay. Yeah.
Well, we receive any and all documents. We've had very large agendas based upon. It's not an unusual thing for us. But if that if those are the documents that the requester is requesting, and you were going to provide it to the requester, then we would suppose that you would provide it to us as part of the record. Sometimes the requester will do it. But
I want to be clear. I don't know what the requester wants everyone to look at. There were 11,000 pages produced. There have now been over 20,000. I'm not sure if he wants to talk about a particular case, if he wants to talk about a particular record, a particular cover letter, or what. If he wants to talk about everything, I guess we can arrange that. But if he wants to identify, hey, I want to just look at this one case because it's representative of the whole issue, then that might be a better way to go.
Well, it's really based upon his original request. If his original request specified, he wanted to know about a specific case, then I'm pretty sure that would be it. And I would agree that if somebody said, I want to see all documents between, for the past 10 years, that could be considered, voluminous in that way. I just was wondering, but I want to get back to just the redaction log. When was whoever was doing the redactions, were they keeping track of each redaction? And how do they know what is to be redacted or not? Did somebody provide them with a log of some sort?
So there wouldn't be a log to tell the attorneys what to redact. The attorneys will all review the files, and they will use what's specified in 832.7 to decide what to redact. As far as creating a kind of log, I think what you're referring to is our cover letter that we would often send for files that would say, here's the various reasons this file has been redacted, all this identified information, and we would list that out, medical records, that kind of thing. We didn't say, it wasn't keyed to each page because some pages could include 40 redactions or one, and they're all obviously names or telephone numbers. So we didn't go through and tag at each one. We would just say, if there's one of these that you want to challenge or look at, if you can't tell what it is, let us know and we'll be more specific with you. That was the process we chose leading up to how we're going to do it in the future, which is different now.
Okay, so did you mean something else when you said that there was a redaction log?
going forward, going forward on the next stop, or whatever it's called, the online portal, you're going to be able to see right on top of the redaction the letters that refer to what is underneath the redaction, and then there will be a key at the end that says PII means this, and this is the statute that authorizes redactions for PII. That kind of thing. You meant the redaction log in regards to the next request system. That will be the key. There's no log, but you can actually see it right on the redaction, and then it's keyed to a big sheet that says anything marked PII is this redaction. Okay. Does that make sense? So yeah, it's a log right on the document.
Okay, maybe I misheard you, but I thought you were talking in past tense, that there was an existing redaction log.
No, we chose to do the cover letter that informed them the general required redactions under 832.7, and then if they wanted to challenge one, they could. I would note we're not redacting files for any reason other than 832.7 CLETs and quarter photos, all of which is required to be redacted under the statute.
I'm not addressing that point. That's a point that might come up at the task force hearing. I'm just trying to make sure that we have all the information that's needed so the task force can make an informed decision, and just to get clarity based upon your testimony. So let me ask it a little differently. Who did the redactions on these documents?
Not one person did not do the redactions. There's an attorney assigned to each case. So one attorney reviewed different cases. So it really has to require us to drill down into a single case to understand, okay, what page are you talking about? You know, there was this attorney assigned to that case.
And there's no documentation for that redaction for whoever is doing the redaction for that case. There's no documentation as to why or reference to that redaction that's attached to the case file.
No, there is. There's a cover letter that comes from that attorney, and is written and says, here's all the reasons that this file has been redacted. Okay. And here's the code sections, and here's, if you want to talk about any of these redactions, let us know.
Okay. So that
either come from me or whatever attorney reviewed the case.
Okay. And are these attorneys that are from the city attorney's office, or they are hired in part and parcel to the Department of Police Accountability?
These are staff attorneys of the DPA.
Okay. All right. And my next question regards your last point around privilege. Are you referring to attorney-client privilege?
No. The complainant brought up some issues about the balancing test and the interaction between the Sunshine Ordinance and state law. And he's done that a number of times in a bunch of letters and correspondence. And that is, I can't speak to that. I'm not a city attorney, and the only person who could advise the commission on that is your attorney.
Well, they can advise you, but the attorney doesn't necessarily speak for you. They advise you so you know what to decide on what should be said.
That's correct. I mean, advise you. I can't make a legal argument to you about what is an appropriate use of the interaction between state law and city law. That is something that I can't issue that opinion. That's something only the city attorney can advise them.
Okay,
and make arguments about. I can't take a representation on behalf of the city.
So I'm going to say here for the record, and I'm hoping that it'll come, but I think that you're going to need to provide a little more information around that privilege, and if you as the representative, it's going to be the same person to represent DPA at the task force hearing, to be prepared to answer that question. We're not going to go on a goose chase to chase down the answer to that question if you're going to bring that up as part of your defense.
I'm not bringing it up as part of my defense. The complainant wants to talk about that, but that we don't use it. We haven't used it in any of the files I'm aware of. And if the complainant wants to refer to a particular file and say, hey, this cover letter says you're using this balancing test, then we can talk about it and whether or not where it's being used. But he's kind of making an abstract legal argument that it would not be appropriate for me to just opine on.
Okay, so you're saying that it's not, so the balancing test in your eyes and in DPA's eyes is not applicable to this request?
To this complaint, mostly because I can't figure out which case he wants to talk about, and I'm not aware of it being used in that way.
Okay.
And if we can drill down into what he's complaining about and the actual use of the balancing test, I can respond to that.
Okay. Well, we're not going to get into that here. I just wanted to. I heard a disparity. I wanted to just address it so that we can explain some of these points to the task force in our opening summary, so that they have as much information to go on as possible, so we don't have to spend too much time at the task force level. That's all I have in questions. I will just note for the record also that it would be helpful for the task force to know of previous orders of determination with regards to charging the public for documents, public documents. The ordinance is very clear on that, that the charges are to be only for the cost of the actual medium itself, and in some cases, for the actual materials for copying. The creation of a new document is, we have extensively had discussions around that, and excerpts of existing public documents are not considered new documents. So I would just want to note that for the record and for the task force to know that we have history of that. That's all I have right now.
Yeah, just to follow up on that, because we are talking about video, I believe that the city can ask you to pay for a drive, or you can supply your own drive for the content to be presented on.
Right. It's a physical medium. That's
right.
Really what it's all about. Yeah.
Do we have any other? Sure. Please go ahead.
So I think the DPA's position is better than what I expected. So if it is, then that's great for everyone involved. If their argument is going forward, they will give me the reductions in the key or footnote. Fantastic. My complaint in that respect has done its purpose, which is to force them to comply. I think, and maybe they should correct, because it seemed like there was a little confusion of what their position is. The records before I filed the complaint had no cover letter and no key. I then filed the complaint. Then they provided the cover letters, which meet the rule for 6727, which is the written justification. And they're saying now, from here on out, they'll also comply with 6726 for the keys for specific records. And if that is, I want to make sure I've understood their position, because that's what I just heard them telling you. Finally, on the B6 issue, the problem is they have a policy that states that they can redact B6 for gruesome or other subjective reasons. And I can't tell you which is under that one, because they won't tell me which ones had a B6 redaction. That's kind of the catch-22. So hopefully we'll know that by the full task force. But if they don't tell you, how can I tell you? So anyway.
Okay. I have a question for the respondent. I'm curious, just regarding that comment. is the reason, or was the cover letter supplied after the complaint was filed in response to the complaint, or because that was a new part of your process at that time?
It was not in response to the complaint. It was part of our new process of including these cover letters. The initial cases that the anonymous complainant requested were the cases that were sent to the public defender's office in the ACLU on an expedited basis. And so those were the first initial round that got sent out, and they didn't include necessarily the cover letter that listed out all the redactions. After that initial round, we started doing the cover letters so that people would have an opportunity to say, hey, you put something in this cover letter that says you redacted X, Y, and Z, and I don't agree that that's an appropriate use of the redaction. Then they could challenge it and figure out what was in the file. So it wasn't necessarily in response to the complaint. Does that answer your question?
I was just trying to figure out, yes, it does. I was trying to figure out the sequence of events, and I think I understand from that. Yeah. Members, do we have any other questions or any discussion amongst ourselves, or are we ready for a motion?
I have one more question for the respondent.
Please go ahead.
Real quick. In the Penal Code 832.7, subsection B6, which you're citing for the redactions, are you holding that is not applicable to the Sunshine Ordinance?
No. I'm not sure. Okay. I'm not sure I understand what you mean.
Well, I'm just trying to ascertain, and I'm not sure if you were implying this or whether you had said it, but that the reason why you provide these cover letters and not a keyed redaction was because of what the 832.7 provides. It's not doesn't specify that it needs to be keyed there, but the Sunshine Ordinance does.
Well, let me say it this way: the reason we provide the cover letter is to explain to requesters that this file is going to have to be redacted, and here's all the reasons it could be redacted. 95% of those reasons are going to be the reasons listed out in 832.7. There may be also CLETS information, which we would then list in the cover letter. And there are also, for example, in an officer-involved shooting, there may be autopsy photos which can never be released. And so we may cite that code section as well. And the purpose of that is to give the requester an opportunity to challenge the redaction if they want, and to understand what's in the file and open up a dialogue between us and them so they can talk about these redactions and we can refer to them.
Okay, thank you.
Does that answer your question?
It's very clear. I understand what you're saying and what your position is. Thank you.
Maybe I'm misunderstanding you.
No, I have a judgment about that, and I'll hold my judgment when the task force hears it. It's not appropriate in this hearing.
Okay. Is that it for our questions? Do we have any discussion amongst ourselves, or are we ready for a motion?
I'll move to find that the records are public and that they are within the Sunshine Ordinance jurisdiction, and to refer it to the full task force.
Do we have a second?
I will second that motion.
Okay, thank you. Now we'll open this up for public comment for anyone who's not involved in the case. Would anyone like to make public comment on this matter? If you need to unmute yourself, press *6. Hearing no public comment, Cheryl, please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Councilmember Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to send to the full task force passes.
Thank you. Please call the next item.
Item number 6, file number 20066, complaint filed by Anonymous against the Police Commission for allegedly violating Administrative Code Section 6721B, incomplete response, 6724I, citation of unlawful public interest balancing test, 26, non-minimal withholdings, 27, failure to cite a specific provision of the law for justification.
Thank you. Do we have the petitioner and respondent here?
Petitioner is present.
Sergeant Youngblood from the Police Commission Office.
Thank you both for being here. We'll hear first from the petitioner. You'll have 5 minutes.
Please let me know when I may begin.
Go ahead, sir.
Thank you. This is PDF page 4, footer page P576 of item 6. This is a much more narrower complaint. And I think as the Police Commission has told you, they did a retraining after complaint 19121, where they do now appropriately do the full cover letters. They have the keys and redactions. Everything's done. So thank you to the Police Commission for following those laws. This is a much narrower complaint. You'll see there's 2 parts of the complaint. One is about these audio recordings. Their argument is that the audio recordings involve the personnel matters of other police officers who those police officers were not the ones engaged in the officer-involved shooting, the great bodily harm, sexual assault, or dishonesty. And they are right, under SB 1421, the portions that are not about the police officers who are either accused or found of having misconduct, unless the comments about those police officers are factual matters regarding the misconduct by the other officers, those parts of the record should be redacted. They do not need to be provided. That's exactly right, but they do have to do that redaction. And they, under both 6726, your own precedent, and National Lawyers Guild versus City of Hayward, they do have to do it. I know it's hard. I know it's time consuming, but it is part of the law, and they do have to do it. That's the first part. The second part is you'll look at their key. They do use 832.7b6 as the reason to withhold certain information. That is the optional public interest balancing test. I don't believe they can use it. Now, it's unknown whether they're just citing it and not using it. I think we've talked about this. You have to cite only what you're using. And if the Police Commission is representing to you, and they may do it here or they may do it at the full task force, that they do not actually use Penal Code 832.7b6, which is the optional public interest balancing test, fantastic. But then they shouldn't be citing it. So it's possible they're not actually using it, they're just citing it. Unfortunately, these kind of letters have the ability of kind of being, standardized or uniform. That's not really how it should be. It should be only the things that are, only the justifications that apply to the records you're producing, right? You don't just cite more things. You have to only cite what actually applies. So I hope their answer to you here today or at the full task force is actually the Police Commission represents that we do not use Penal Code 832.7b6, and it's just a mistake of putting it there. Let's see. I think it's a much narrower case here. It's just about these audio recordings and not using Penal Code 832.7b6, the public interest balancing test. Thank you very much.
I'm sorry, sir. What was that citation you just said? Anonymous?
Hi, the citation is Penal Code 832.7b6, and my argument is either they shouldn't cite it if they're not actually using it, or if they are using it, they should not be allowed to use it. Thank you very much.
Thank you. Is the respondent ready?
Yes.
Okay,
You'll have 5 minutes.
Hang on, Lila.
Sure.
Go ahead, sir.
So the commission offers did list that exception in error, but this is about the chief's performance evaluation following, following an officer-involved shooting. As to his decision to put officers out on the field, the chief's performance evaluation is not an SB 1421 document. The underlying documents may be disclosable from a PRA request to the department, but they are not entitled to learn what documents were used in a chief's performance evaluation or the closed session deliberations. If anyone wants the chief's evaluation, that's a personnel order, which will need to be obtained by a court order. And as for the 832.7B6 argument, the city attorney's office, the supervisor of records, has issued a determination that it was permissible for the commission to rely on the balancing provision of 832.7B6. Thank you.
Thank you.
Was that a respondent, sir? Did you want to provide your name or say something to identify yourself? Because I didn't get.
This is Sergeant Stacy Youngblood from the commission office.
Mr. Youngblood. Okay, sorry. Good.
Members, do we have questions for the petitioner or the respondent?
Yes, I have a question for the respondent. Sergeant Youngblood, hello. How are you this evening?
Hello.
You just mentioned that the chief's performance evaluation, was that something that was discussed at the police commission itself in closed session? Did I hear you correctly?
Correct.
Okay, and you're citing that as not a public record, but a personnel record?
Correct.
Okay, thank you. That's all the questions I have.
Member Wong, do you have any questions?
No questions for me.
Are we ready for a motion up?
Yeah, I'll move that find that the records are public and that they're within the jurisdiction of the Sunshine Ordinance and to refer to the full task force.
And I will second that motion.
Okay, thank you. We have a first and a second. We'll now open it up for public comment for members of the public who are not involved in this case. Use *6 to unmute yourself. Is there anyone wishing to make comment? Hearing no public comment, please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to send for the full task force passes.
Thank you, everyone. Please call the next item.
Item number 7, file number 20074, complaint filed by Anonymous against Dennis Herrera, Elizabeth Coolbrith, in the Office of the City Attorney for allegedly violating Administrative Code Section 6721B, incomplete response to public records request, and 6721C, failure to provide written statement as to the existence, quantity, form, and nature of records.
Thank you. Do we have the petitioner and respondent here today?
Petitioner is present.
This is John Cote with the City Attorney's Office.
Thank you both for being here today. We'll hear from each of you in order for 5 minutes. Petitioner, please go ahead when Cheryl do the signal.
Please let me know.
You may begin.
Thank you. There's no presentation for this case. This is a very different case than the other 4 you're hearing today. This is for SB 1421 and Becerra versus Superior Court First Amendment Coalition records, retained, prepared, used, or owned by the City Attorney's Office. Their response, and And it is nice because this is the one time it is actually a detailed legal response from the city attorney's office versus many of these other respondents. So they have argued that everything is attorney-client privilege or attorney-work product privilege. I think that if they have actually conducted a search and actually reviewed all the responsive records, and they are representing you that every single record is privileged, that's one story. But I don't think that, and the reason reason I'm suspicious is in a prior records request, and Mr. Cote may be familiar with this, about enterprise systems catalogs. I got a response like this. They told me that the rest of the stuff is all attorney-client privilege and attorney-work product privileged. And as I kept pushing and pushing, eventually they gave me more records that were not privileged in any way. And my worry is that the city attorney's office uses this as a blanket exemption, not a blanket exemption, a blanket response. The CPRA requires that you search for all the records, then you review all the records, and you have to actually determine every single record is in fact exempt. You can't just kind of conclude logically that they must be. And the Sunshine Ordinance goes further and requires that unless every single portion of every single record is exempt, you have to give the you have to redact the minimally exempt portions. Now, my key argument is I don't think that the opinions of the attorneys of the DCAs and the communications back and forth between the DCAs and the DPA, SFPD, or Sheriff's Office is not privileged. Of course, those communications are privileged. I'm not challenging that. And the internal communications of the city attorney's office, when one attorney is talking to another attorney about how they can argue something, that's work product privilege. Of course it is. No dispute there. The question is the city attorney's copies of police reports, body cam footage, other things, factual evidence that is not their own attorney's impression of the law, nor a confidential, nor, quote, the secret of a client, which is what's protected under the Business and Professions Code, that an attorney is prohibited from disclosing. I argue that those records are not secrets of a client and should be disclosed. These are just the copies that the city attorney's office happens to have, similar to Becerra versus Superior Court, where the attorney general happened to have some copies of records that they should disclose. The second issue is about whether they have to tell me the number and existence and nature and form, I believe, of exempt records. This is very interesting because there is a court case that says a particular provision of the Sunshine Ordinance declaring that Herrera's communications with others are public. The court has correctly, in my opinion, said that provision of the Sunshine Ordinance violates state law. They are correct in that. They're correct in that argument. The question is the knowledge of how many records exist and whether they're, say, emails or police records or something or body cam footage, is that information about the records itself privileged? And I would argue it's not privileged because otherwise privilege logs would never exist in courts, right? If that kind of information was privileged, privilege logs themselves would be a violation of attorney-client privilege. And ironically, in St. Croix, the case that they will cite to you, in that case itself, it tells you how many privileged documents there were. And that's evidence that the number of privileged documents is not itself privileged. And that's all there is. Thank you very much.
Thank you. Is the respondent ready?
I am. Again, this is John Cote with the City Attorney's Office. We sent a detailed written response to the task force on this issue on December 15th, last week. I would refer you to that response, and I yield back the balance of my time.
You done, sir?
Yes.
Okay.
Thank you. Members, do we have questions for the petitioner or the respondent?
Is the commission still there? Is my line dead? Is anyone here still?
We are still here. We are contemplating the matter in front of us. So members, this is reminding me of another recent case involving the public defender's office. Member Wolf, you're looking like you think this is related or not related? We can't hear you. I think you're on mute.
Not quite related. It's a little bit of a different context, I think, considering the the reasons being set forth by the respondent are not the same.
Except for the references to work product and attorney-client privilege. But yes, I see what the reasons are different.
Yeah, it was a different case, and they're not citing that case. I will say for this case, frankly, all cases, that one of the things that we should absolutely make sure of, that as they are presented here for the record, whatever defense or I shouldn't say defense, actually, it's better to just say citations that allow for withholding by the respondent, those need to be carried up to the task force as being the official reasons. You want to make sure that that doesn't change from what we're hearing here today and receiving in the record, from what we will hear in the future at the task force.
Just to reiterate what you're saying, that whatever the response, the reasons for response need to match the reasons for response that are given to us, and those should not change over time.
Well, yeah, it shouldn't change between this hearing and the task force hearing. We're just hearing it as and collecting the record. So if the task force is expected to make decisions based upon the evidence that is presented here today, it can't then just change. In testimony, it can't just change based upon what was already presented, which is also the same reasons. Has nothing to do with the task force. It has to do with the reasons they give the requester, and that there's going to be a withholding of some sort. So that reason should not change. And if it does change, then the task force has to weigh that clearly as to whether that changes the entire nature of the case or not, of the file and hearing or not. I just want to be clear. It's been a bit of some concern over time that sometimes it changes. So I want to make sure I appreciate the Office of the City Attorney putting things in succinctly in writing here. It makes it makes it easier, and for all the respondents that do so in fashion like this. That's it. That's all I have to say.
Okay.
I'll move to find the records public and within the jurisdiction of Sunshine Ordinance, or refer to the full task force.
Do we have a second?
Yeah, I think I will second that motion. I would definitely like to get advice probably from DCA Price Wolf on this specific case. I think that would be very helpful prior to it going to the full task force.
Have you formulated through the chair? Have you formulated a question?
Member Wong, are you asking that we modify the motion to include that?
I guess I could go either way. I think I mean, I would personally like to have that advice. So.
Okay. All right. That's fine. You can certainly engage legal counsel on your own as need be for clarification. Yeah. Okay. Yeah. That's all I have.
Okay, so we have a motion and a second to find jurisdiction and that the documents are public records and to send to the full task force. And I guess seeking advice from DCA Price Wolf is not part of the motion, but just something that we will do on our own. Okay, not part of the motion. Do we have any public comment on this motion from individuals who are not party to the case? If you're on mute, you'll need to press *6. Hearing no public comment, Cheryl, could you please call roll?
Member Wolf?
Aye.
Member Wolf, aye. Excuse me. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to send for the full task force passes. And I just want to clarify that there was no additional request in that motion for advice from our DCA. That's just a request I will send to him along with the minutes from this particular action. How does that sound?
Thank you. That's correct. Okay. Thank you, everyone, for being here today. Cheryl, if you could call the next item, please.
Item number 8, file number 20110, complaint filed by Anonymous against Sheriff Paul Miyamoto, Austin Lambert, and the Sheriff's Department for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner, 26 by failing to keep withholding to a minimum, and 27 failing to justify withholding.
Thank you. Do we have the petitioner and respondent here today? Is the petitioner here? Is the respondent here?
I'm not seeing any. I only see one phone.
I see one guest. Oh,
And
no,
It's saying it's now it's gone.
Did people
Yeah.
get bumped off the call?
It did look like
well, there it is again.
the petitioner
Excuse me,
may have dropped off.
Sir, speaker.
It may take a moment for it to.
Yeah, let's hang on
register.
one second. I'm just going to speak so that people know that the meeting is still happening. It looks like a few people may have dropped off inadvertently. We are preparing to discuss item number 8 on the agenda. Do we have the petitioner and the respondent here?
Yeah, sorry about that. Petitioner here. It disconnected.
Okay.
I'm sorry,
So
sir. I didn't hear that. What did he say?
Hello.
Yeah.
Excuse me, petitioner. You're here to testify?
This is the petitioner in the case against the sheriff. I can't hear you.
Can you hear me?
Yes, I can hear you.
Okay. We have the petitioner here. I'm looking for the respondent. Is the respondent in attendance? Or was the respondent in attendance? I'm looking at the list of people participating in this call. I believe we only have the petitioner. Victor, do you happen to know, was the respondent previously on the call, or is that unknown?
That is unknown. I'm unable to know who is actually calling.
I will say, Lila, just Chair LaHood, for just I think when you close that last case, I think it would have been easy for people to think, oh, it's over. So that was what I think you said, but I could be wrong because our petitioner is still here. I don't know if the respondent ever was.
Well, did you have any communication from the respondent about their plan to attend this meeting?
I don't believe I received any communication. Had I, it would have been included in the record.
Okay.
And
if that's the case, I think we should proceed. I know I thanked everyone for being here. I meant the participants in the last item. I didn't mean for everyone to go away. I will try to be more careful next time. I'm wondering if the respondent was ever on the call. Let's hear, unless anyone has any concerns about this, I would like to hear from the petitioner. Members, do we have any concerns, or should we proceed? I'm not seeing any concerns from the members of the committee. So, petitioner, you have 5 minutes.
go ahead, sir.
Thank you very much. Thank you. So I don't believe, and maybe the clerk can clarify to you after my speaking time is over, whether there was a written response to this one. I don't remember. I don't think I've found one. But this case is against the Sheriff's Department. It's for their SB 1421 and Becerra versus Superior Court First Amendment Coalition 22 record. 2020 record. They are not providing audio and video records because they claim that it would be too burdensome to provide audio and video records. They claim that because, in a similar way that the DPA claimed, that they said because a prior record sequester did not demand the keys and redactions, that when they give it to me, they did not give the keys and redactions. I don't think that that's a lawful reason not to give me keys or redactions. I was hoping that, like the other respondents, they would come here and then agree to give me keys and footnotes going forward, but apparently they're not here. What else can I say? Oh, there's an interesting issue in this case where they decided to put the somebody needs to mute, I'm echoing. They decided to put the record behind a sign-in wall that requires you to agree to various Microsoft terms of service, privacy policy, etc. And I don't believe that you are allowed to have a third-party entity, a private entity under the CPRA, to control access to public records. In fact, there's a specific provision in the CPRA about that. And moreover, there is a court case, Santa Clara County versus Superior Court, where they determined that you cannot create end-user conditions on the distribution of public records. Now, their holding was underneath the copyright law. They found that it doesn't matter what federal copyright law says, you can't impose conditions when you release records, like licensing conditions, to the respondent, to the requester. And what I'm arguing is that court case combined with the CPRA provision does not allow them to say that we're going to kind of put these records behind a wall where you have to provide your username, password, stuff like that. These are public records. They're disclosable public records. They admit they're disclosable because they release them, and they have to provide them completely publicly. For example, using NextRequest or emailing me the records or whatever else. They can't require me to jump through hoops involving agreeing to end user license agreements or terms of service and stuff like that of Microsoft. Yeah, they don't give me, there were no keys or footnotes, there were no audio video records, and they kept them behind this wall. That's all. Thank you.
Thank you. I am looking at the attendees. I do not see anyone who could be the respondent. Members, do we have questions for the petitioner? Yes, Member Wolf.
Yes, petitioner, you mentioned that they were withholding or had placed these behind a registration wall or some sort of security wall for the purpose of protecting copyright. Did they cite how or what or why they're claiming copyright privileges?
No, let me correct that. I didn't communicate that clearly, obviously. What I'm saying is the court case, Santa Clara County versus Superior Court Appeals, Fourth Appeals, they said, that court case said you cannot require as a condition of receiving public records agreement to this end user agreement. And they made that holding because federal copyright law cannot override state public records law. That's not what the respondents said. The respondents, without a legal citation, said, we're just going to put it behind this sign-in wall. I had informed them that they couldn't do so, and they kept doing so. They did not state that copyright was the reason. They stated that the security of the record was. And this is very strange because these are the redacted end result records that are completely public. They're distributed to news organizations. It's unclear what reason they had to not give them out completely publicly.
Thank you.
But they didn't cite copyright, so yeah.
Okay, all right. I misheard that.
Do we have any other questions, or are we ready for a motion on this?
Ready for a motion. I'll move to find the records public and within jurisdiction of Sunshine Ordinance and refer to the full task force for hearing.
And I will second that motion.
Is there any public comment on this motion from members not involved in this case, which I don't think is possible because I don't see anyone available to make comment. So, Carol, please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion is sent until full task force passes. So I believe that concludes all of our cases.
Thank you, Cheryl. Let's call the next item on the agenda.
Item number 9, effect/application of the Sunshine Ordinance on government social media accounts. And I believe Member Wong provided a PowerPoint for that particular matter.
Yes, thank you. Member Wong, would you like to discuss this a little bit and tell us what we're looking at here?
Sure. Yeah, so I put together this presentation after hearing from a member of the public who is being blocked by a social media account run by the SFPD Park station. And so I'll just go over this little presentation with you all. So starting on the first slide, which is footnote P770, you can see this cover page. Oh, sorry. Member Wolf, do you mind muting, please?
I'm sorry.
Thanks. So yeah, I'm going to talk a little bit about government social media accounts today. And then moving to the next page, which I think is page 3 of the PDF. So just as an overview, the question that I was trying to ask was, can Twitter accounts that belong to government officials or departments block users? And the tweet that I have linked here is evidence of the SFPD Park station blocking this particular member of the public. So you can see in the image that they are blocking them on Twitter. And so what I started to do was just a bit of research on existing case law. So that is the next section. So we can move on to page 5 of the PDF. So one of the first pieces of existing case law is this case called the Knight Institute versus President Trump. So I have a couple of links here which go over some of this case law, and it both has the complaint made as well as some analysis. But one of the things I wanted to point out was quote by the judge, Barrington D. Parker, who is part of the Second Circuit Court of Appeals, who says that the First Amendment does not permit a public official who utilizes a social media account for all matter of official purposes to exclude persons from an otherwise open online dialogue because they express views with which the official disagrees. So this is a clear, I think, case that shows that you can't block members of the public if your particular account is discussing official purposes. Moving on to the next slide, there is also another piece of existing case law, which is Davidson versus Randall, who was part of the Loudoun County Board of Supervisors. And this was actually found in favor of the complainant, Davison, by the Fourth Circuit Court of Appeals. And part of that case has this quote, which is that the appeals court observed that the Facebook page had all the hallmarks of a public forum and that blocking access was a, quote, black letter viewpoint discrimination. So similar to the previous case, which was actually a case related to Twitter, this case was found in favor of this member of the public and applies to actually Facebook pages. And then moving on to the next slide, the last piece of existing case law that I found was Hyken versus Ocasio-Cortez. So there were actually two lawsuits filed by Dov Hyken, who is a former New York State Assemblyman, and then one by Joseph Salandino, who's a social media personality, against Congresswoman Ocasio-Cortez. And so this particular lawsuit, Hyken, was actually filed, or excuse me, it was settled out of court and also required, and also was following an apology by Congresswoman Ocasio-Cortez. So again, we can see that you can't block people on Twitter if you're a government official using these particular social media accounts for official purposes. So moving on to the next slide, something I also wanted to do was to determine whether or not the SFPD website was providing the same information as what was provided by social media. And so I took two screenshots. Moving on to the next slide, you'll see a screenshot taken on November 24th at 1 p.m. of the San Francisco Park Station page. And you can see here there's a police request, there's a newsletter, or a couple of newsletters from previous months, actually previous years, since they're from 2019. And then one investigation regarding a shooting in Haight-Ashbury. So you can see that their most recent post on the website was from August 7th, 2020. And then if you go to the next page, you can see a screenshot from the Park Station Twitter account. And you can see that actually the most recent post from them on their Twitter account is from November 21st, 2020. And it actually reports that there's a wanted fugitive in the 100 block of Lake Street. So somewhere in that particular district. So you can see that actually their Twitter is much more up to date than their website. So information found on their Twitter can't be found on the website. And therefore, like moving on to the next page, my conclusion was that I don't think that these government accounts should be allowed to block members of the public, especially because they, in this particular case, they are much more up to date than the actual official websites. One thing I wanted to note was that, interestingly, after I was kind of tweeting about this on my personal account to this member of the public, the SFPD Park Station did unblock this member. So I found that also a little bit interesting. And that member had been blocked for years, not just for like a few days or weeks or anything like that. They had been blocked, I think, for somewhere between 2 and 4 years. I don't recall exactly. So a couple more conclusions was that I think the sunshine, so we've moved to the next slide, which let me just catch up on the PDF so I can make sure everyone's on the same page. So that is page 16. of the PDF. So I think that Sunshine Ordinance actually can be loosely applied based both on existing case law. Oh, did I actually skip ahead? Excuse me, I did actually. I'm sorry, I skipped ahead a couple of slides. Apologies. So I forgot to go over the applicable legislation, which is starting on page 8 of the PDF. So page 9 of the PDF, we can look at section 6729 of the Sunshine Ordinance, which states that each department of the city and county of San Francisco shall maintain on a World Wide Web site or on a comparable readily accessible location on the internet information that it is required to make publicly available. Each department is encouraged to make publicly available through its World Wide Web site as much information and as many documents as possible concerning its activities. So, as I had mentioned earlier, the website is actually not as up to date as the Twitter account. So I would say that the Twitter account is the thing that needs to be more accessible or publicly available to the citizens of San Francisco. And then going on to the next slide, also in section 6729, we see that each department shall make reasonable efforts to ensure that its World Wide Web site is regularly reviewed for timeliness and updated on at least a weekly basis. So I think we could probably find a violation for both, for that particular website not being up to date in the case of Park Station. And then lastly, on the next slide, we have the SFPD social media policy, which I have linked. And then there's actually specific details on blocking people from social media accounts. So the quote says that individuals who repeatedly post content on Facebook, Twitter, etc. that violate this policy may be subject to being blocked from the social media page for a period of 48 hours. So it would have been fine based on this particular policy that SFPD created to have blocked that member of the public for 48 hours, but considering that they had been blocked for years, I don't think that qualifies. So now going back to page 16 of the PDF, my conclusion is that Sunshine can be loosely applied by using section 6729 and the existing case law that I've presented. And then the information provided on social media differing from the websites is not great. And also, if you're going to have the social media account be more up to date, that is the thing that should be publicly available. And then, so the last slide is something that I wanted to put forth to members of this committee and then possibly the full task force is how do we apply Sunshine to future incidents of like blocking of social media? Like, is this something we may have to consider in the future? Do we want to kind of set out some precedents for it? And then secondly, how do we decide if information on websites is sufficient versus the information that's available on social media accounts? And that's it.
This is great. Thank you.
I have a couple of questions.
Please go ahead.
So thanks, Jen. That was really great, and it's always a interesting subject because it's kind of new in a way since Smith versus San Jose. Some of this stuff has come up, and because of the outgoing president, so to speak, and the cases that you brought up. But I have a question. Would you consider, or as part of your research, is it a question for you that no matter where information is posted, that comments should be made available?
As in comments on those social media posts themselves?
Yeah, because it sounded like you're making the argument that, for instance, with the Park Station, that their more recent information is posted on Twitter versus their website. But there's clearly a difference in implementation and usage of Twitter versus a standard website. So how do you reconcile? How do we reconcile for that? I mean, because you're kind of making two arguments in a way, right? This was all stemmed from a person being blocked for a very long time from access to information that was being posted on Twitter versus possibly not posted on the website. But then also making the same kind of a similar argument that the information that's posted on the website should be, one it should be considered the official World Wide Web posting site over the other. So.
Yeah, so I guess the main argument that I am making is that the social media account should be made available. That's the main point that I was trying to make. And I think the fact that it was more up to date than the website just adds to that argument. So it's kind of like the secondary reason that it definitely should be made available. But again, it's like secondary to the fact that it should be made available at all times anyways. That's essentially how I feel about it. And that's how I feel that like existing case law has basically found.
I have a follow-up point to make on that, if you don't mind. We have found, that, and it is held that, and as some of your references post, that websites or any presence that are being used in the official capacity of that person's position as a public official must be open and public as possible, unless it violates that platform's policy, of which the platform will take action versus the public official. As if the public official were to hold a public forum in a room, they are, free game to have comments made to them directly. And unless there is a rule on decorum or what have you, that is in relation to that specific meeting or room, then they could be removed or silenced. So, yeah, I just wanted to point that out, that might also lend kind of in a broad brushstroke. It doesn't really matter. Any government, anything that is using the web for promotion in its official capacity can't block anybody from anything, especially if it chooses a forum-based platform. I mean, Twitter's not necessarily a public forum because Twitter's a private company. It's a private, even though it's accessible to the general public. It's only accessible to the general public if you choose to sign up for in their registration. So, there's that part too. But yeah, thank you very much. I really appreciate it.
One thing that crosses my mind, Member Wolf, you mentioned, if there were a public forum, there would be opportunity for public comment, but that public comment would have constraints. It might be 2 minutes per person, or if you want to submit a statement, there's a word limit on that. What about the issue that on social media, the opportunity for comment is infinite? And are they, I'm curious, Member Wong, you mentioned the policy about blocking for 48 hours. Not having read the full policy, what would trigger that? And let's say it's on Twitter or on Facebook. Like if somebody posts 50 comments, does that mean that they are temporarily blocked because they have, exceeded the allowable commenting? Can you talk a little bit more about that and what you think of that and how those constraints should be applied?
Yeah, so SFPD social media policy doesn't specifically address like what repeatedly post content means. So it doesn't give any specific constraints. I will say that to Member Wolf's point about the platform itself regulating users, I think, if a person is repeatedly saying specific things, if they're saying things that don't fall within the usage guidelines of the particular platform, then it is up to that platform to block the user, to remove content, etc. And then related to the particular member of the public that I was speaking with, they actually, all of their comments seem to be still intact on the SFPD Park Station Twitter account. So I will say that I don't think that they actually removed any specific comments, I think, which is a good thing, but did block for quite a long time. But yeah, I guess personally, I don't foresee it being an issue if someone is going to respond 50 times with different information each time, or having almost like a one-sided conversation. And if it does become a problem, I imagine that Facebook, Twitter, other social media accounts would, or companies would, manage that from their end.
And if I can answer your question to me, it harkens for me back to Code Pink's protests at congressional hearings, where they would, randomly, would disrupt an exercising their First Amendment rights, kind of to protest and vocally inside congressional hearings, and you see them getting dragged out, kicking and screaming. Okay, that area of comment is, to me, very different than being on, let's say, Facebook or Twitter or any other kind of social media where open commenting is allowed, because there are rules of order for specific hearings, and they have lots of guardrails with regards to being able to do the people's business without interruption. That has nothing to do with social media and the ability to make open-ended comments ad infinitum, because the platform allows it. It's the function of the platform. It's like, going to, I don't know, you can go to an amusement park and, go on the same ride as many times as you want, as long as you got a ticket to get into the park. So it's, I think we need, this needs to be compartmentalized, and it needs to be made clear that the differences in implementation, that the social media, anything on social media, unless it's created and managed as some sort of something accessible on the city's website itself that it quote unquote owns, and can make rules about, it doesn't apply to general social media at all, period. And if there's really any concern about that, then those public officials and departments and agencies should just not use it. That period. It's like, if you're going to go out, it's kind of like going out in the public square, in the public common space, and getting on a soapbox and announcing things. Well, people can stand out there while they're listening and say anything they want to you. It's not a public hearing. You're just standing out there blowing your horn. So that's how I kind of regard social media as kind of the public common space, and the laws of the general laws of conduct, in public apply, which would be the same guardrails that, or similar guardrails that a company would put on their users for it. So anyway, it's a great question and great discussion. I appreciate it.
I think that's a good comparison. You're right. It's not taking up limited space. There's infinite space. And so letting people comment as much as they want, and commenters, one would think would recognize that at a certain point, if you keep going, you are maybe losing attention for your argument. But that's not our responsibility to dictate. If people have more to say, they can keep saying it. And I think these are very good points. Do we have anything else to say on this matter, or and is there any action that we need to take, or should we open it up for public comment? Before I open it up for public comment, Member Wong, is there action that you want us to take?
The only thing that I could think of is like, I wasn't sure if it made sense to present to the full task force or just to pass the PDF on to them. I don't know if there's any action that needed to be taken.
I would recommend that we. I think we should pass the PDF on to the full task force. Member Wolf, do you want to have a discussion there as well, or a presentation, or no?
We have had presentations with a Q&A, and if Member Wong is open to it, now that we've heard it, and might, take whatever parts of our discussion and, make it part of whatever, sure, why not? It's up to you, Member Wong.
Okay. I guess if we somehow needed to fill time in a full task force meeting, I'd be happy to present it, or I can just keep the presentation a little bit tighter so it's shorter.
How about this? How about doing it at the next orientation meeting?
I think that's a great suggestion.
Sure, that sounds great.
Okay, very good.
So do we need to vote on that, or is that at your discretion? Okay.
We can if you want, but I can certainly do that. That's fine. And Member Wong can certainly ask for it to be put on the agenda. So.
In that case, I'd just like to open this up for public comment. Is there any public comment on this?
Yes, please.
Just a minute. Go ahead, sir.
Thank you, and I wanted to thank Member Wong. I think this kind of analysis is great, and I wish the task force, and I'm sure it's because you're all volunteers and time limited, had the opportunity to do more analysis of topics related to Sunshine and First Amendment and stuff before the public, because the public can comment on these too at the full task force when there's more people. Regarding the substance of the discussion, I think Knight First Amendment Institute versus Trump has been somewhat overlooked when people try to enforce their rights. I don't necessarily. I believe the courts have held that while Twitter, Facebook, etc., themselves do not have to comply with any First Amendment laws or any public forum laws, it's the officials themselves that has to comply with the public forum laws, right? So it's Trump himself who has to comply, or maybe in this case, SFPD that has to comply. Twitter can do whatever it wants to do. Related to that, a few months ago, I had actually made records requests for the blocked list of many different agencies, not only in San Francisco, but throughout California, in an effort to enforce Knight First Amendment Institute. And it turns out that the city attorney's office, for example, blocks many different people. And, I don't believe that is lawful under Knight First Amendment Institute. And what I worry is it's unclear whether that can be really enforced through the Sunshine Ordinance, because the idea was that was found to be a violation of the First Amendment Institute, First Amendment, because it's viewpoint discrimination. But the Sunshine Ordinance doesn't really. I know that there was a reference about how 6729 could be used for that, but I think it would be pretty difficult to use the Sunshine Ordinance itself. I think that actually goes to the second part of what Member Wong was saying, which is that the fact that there's some information you can only get through here, regardless of whether you can comment or not, may in fact be discrimination in releasing public information, which there could be a complaint under the Sunshine Ordinance. But again, thank you all for this discussion. It was really interesting. Thank you.
I have one more comment,
Sure,
Madam Chair. In relation to the public testimony, what we have done in the past, which was based upon a complaint that was brought forward to the task force, was we have ruled that a block list be be made available based upon Smith versus San Jose, because it is part and parcel to a public social media account, as was discussed, I believe is discussed in that case, though much of that case was around text messaging. But in the end, the interpretation of that, I believe the way it was presented to us, was that it included social media also. That if there was a request to provide, information with regards to the online account, as it would for an email account, that it would be up to the discretion of the respondent. But block list could be part and parcel to that.
Great, thank you. So I think we have a plan for Member Wong to present more to the full task force at our next orientation session. And I think we are ready to move on to the next item. Cheryl, if you wouldn't mind calling the next item.
Next item, item number 10, discussion regarding compliance with Administrative Code 6721F.
Okay, so we have Member Wolf, as chair of the task force, wrote this letter to me, and Member Wolf, if you could give us the highlights of what you would like us to consider and discuss today.
Sure. So as we all know, the ordinance offers very little authority to the Sunshine Task Force to enforce the ordinance, except in certain cases. And in section 6721E, for example, and if you look on page P788, which is the PDF page 2, second page of this, I've just underlined it in there and took an excerpt from 6721E, which is the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. Okay, so, and then it goes on from there as to, like, if they don't comply, so on and so on. And the task force, has become familiar with its ability to make referrals for noncompliance to the Ethics Commission, to the city, to the district attorney, and to the attorney general, and that members of the public are free to take their cases to the judicial branch. But one thing I didn't know, actually, in all these years, I actually didn't notice, and was interesting because it is emphasized in section 6721F, which is somewhat, kind of unusual. But in the last sentence of it, it says that if a custodian of a public record refuses or fails to comply with the request of any person for inspection or copy of a public record, or with an administrative order under this section, which means our orders of determination, the Superior Court shall have jurisdiction to order compliance. Well, what is the operation of that? How does that get actually implemented? I mean, does it get sent to the Superior Court and then, they have jurisdiction, so they get to take it up, when they, at kind of like as part of their regular business? Or, do we have to do something? I mean, there's nothing operational about it, but what's interesting to it, it's different than, I think it's 6733 or 36, I think it is, which allows the public 6735, which allows the public to institute proceedings for injunctive relief, declaratory relief, or a writ of mandate. And it says any person. I often think is the task force considered a quote unquote person, as is Citizens United considered a person, so to speak. So I'll just stop there. I just pointed it out because as we begin to move forward with more review with regards to compliance, whether this is another avenue that we should be looking at.
These are good questions, and it's, when you said, it gets sent, we need to know who the actor is. Are we the actor doing the sending, or does it mean that avenue is open to petitioners who receive orders of determination, and thus they can do that ostensibly with our support, but that it's not our responsibility? Regarding the compliance, I did have a question, and you and I were talking about this a little bit before, in terms of who is responsible. So we issue an order of determination, and in terms of ensuring compliance, are we responsible for ensuring compliance, or is it if the petitioner receives an order of determination and a compliance doesn't happen, it's their responsibility to tell us, and then we proceed with compliance?
Well, one thing that as we were going through in the orientation, and I have mentioned this before, that in our complaint procedure, there is in section E, once the order of determination is made, the administrator shall send it to the complainant and the respondent, and I'm reading this verbatim, and as necessary, request a written response, which shall be monitored by the Compliance and Amendments Committee, or any committee recommended by the chair. So generally in history, compliance and amendments would naturally, all of the ODs would be in its kind of charge, okay? And if something were to come up regarding non-compliance, then it would automatically be put on the CAC agenda because the OD was there. The question is whether the the question is shall be monitored, which is a very active statement. And I don't recall in the years prior to 2012, I don't recall, or during the years between 2012 and 2014, if the CAC, I hadn't sat on that committee in those times, whether they actively, what monitoring meant. Did they actively contact the petitioner to see if there was compliance or not? And then now we do that now when it's just actively referred, but here it goes, it's kind of an automatic thing.
So when you say automatic and monitored, I like the idea of this. However, if we as the committee are responsible for that, I think we would need additional staff, because I don't think the three of us can. I know that I cannot commit the time that would be required to do that, and I'm going to assume that you don't have that time either. If this is our responsibility, then we need to and I Cheryl, unless, do you have extra time to be doing this? And if not, then we need additional staff to help us do this, unless our monitoring is that petitioners will tell us when they are
exactly. Yeah,
not
I think that's what we need to do is when we make the ruling at the task force level, I think it would be a good idea to tell the petitioner and have them acknowledge that they understand they have to get in touch with us, and I guess we might want to say like a 30-day timeline by the next task force hearing. I would be able to report, maybe put in the administrator's report, who I've heard from, who has said that the respondent has not been compliant. That's something I can add to my report if that's what you would like me to do. But I think we need to make it clear to the petitioner that we need to hear from them.
Well, Madam Chair, we kind of cannot make this up as we go along, because the task force has spent considerable amount of time creating the process and the procedure, and it has been this way since I've been on the task force in 2005.
What do you mean this way? What is this way?
This complaint procedure, this particular section has not been changed since I've been on the task force. So this is how it's meant to be implemented. If the task force is, not following its own procedure, then the procedure should either be reviewed and restarted, or the procedure should be changed. Now, I mean, I didn't read the rest of the procedure in the same paragraph, which requires that if a violation was found, the respondent shall be ordered to provide the record to the petitioner within 5 days of the issuance of the OD. And then it further goes on to say that CAC shall review whether there's been compliance with the OD. So I mean, it could be read that the opening sentence is like an opening statement that orders the determination are, the charge of the Compliance and Amendments Committee and are to be monitored. Then the second sentence is, if they don't comply within 5 days, then triggers the monitoring, so to speak, and makes it active, more active in the form of a review at that point, which means we would pay attention to it. So that's kind of how I'm interpreting it. But
that would mean that then we must also, the order must say that they need to deliver it to us within 5 days. Otherwise, how are we going to know?
That's right. It says if a public records violation is found, the custodian of records shall be ordered to provide the record to the complainant within 5 business days after the issuance of the order of determination. Period. The Compliance and Amendments Committee shall review whether there has been compliance with the order of determination or not. Now, that means that somebody needs to check. If we don't hear from the complainant, from the petitioner, if there was a violation, or we don't hear from the respondent, that we need to reach out and find out if it's...
Yeah, so here's the thing. Having to reach out adds another layer of work and complexity. And unless we are going to have staff that can do that, I would like to make a motion that we amend this to say that the what is requested either we need to amend this to say that it must be sent to us within 5 days so that we will know that it's not, or we need to shift the burden to the petitioner so they have to tell us if they didn't receive it. Which do you think would be would be a better approach? I think either could work.
Either or both.
Member Wong, do you have thoughts on this?
Yeah, I mean, I agree. I think either could work. I mean, it's possible we could also try out one or the other and see how they go, or also just have both options available.
Well, the problem is I suppose if they send it to us, we then know that compliance has happened.
Well, let's go on. Sorry.
But if they don't send it to us and we don't hear from the petitioner, then we are forced to reach out. So I think we need to set a rule. It's either we are saying the documents need to be sent to us as well so that we can know whether it's happened or not, or we need to say the documents need to be sent to the petitioner and the petitioner needs to tell us if they don't receive the documents.
Let me throw this up. Throughout the entire complaint process, there is an exquisite amount of engagement with the parties. That engagement should not end until, if there is a violation, until there's closure. That is the purpose of this section, is to provide closure to the case. And it could be, and that also could be reported, to the task force, that, in these ODs that have violations that required compliance with the ordinance to provide or the records, these orders of determination have been complied with. I think that is absolutely, I think that's an important metric for many reasons. But I think including both your suggestions, I think is very good. I think it's the requester, the complainant petitioner should notify the task force within 5 days of the order of determination being received, that whether there's been compliance, and also the respondent that they have complied, and if not, why not? And we're dealing with this right now. You're on mute.
So we're putting the burden on both of them then. We're saying to the respondent, you need to send these documents within 5 days to the petitioner and to the task force. And petitioner, you need to let us know that what you have received is satisfactory. And if not, you need to tell us why it's not satisfactory.
Yeah, I think a little bit of burden on the petitioner, since they brought the complaint to us. They should see it through to the end.
Okay. So, what is going to be?
Yeah, we got a little off course here, because that wasn't the thrust of what I brought forward for today.
Okay, so what is it? Tell me then. I got us off course, but that's the thing that drew my attention, because it seems like a lot of responsibility. And if we're saying that we are actually going to do this, I think we need a system for it.
Yes. Well, and I think first we need to I always like to try to contact the framers of the ordinance, because what did they have in mind when they wrote that part? What is that? How did they see it being implemented? And if they really didn't, then we should come up with some sort of implementation based upon whether it's jurisprudence or what is a precedent or some commonly understood construction of language, what this actually means, and then hold ourselves to it. I mean, we've done that before in other sections of the ordinance that many folks don't agree with, but we hold that to be true in the way we've interpreted the ordinance for certain sections. So, but the fact that this had this kind of somewhat open-ended and it actually points to our administrative orders, it wasn't clear as to who's the active party here that engages the Superior Court.
I was going to say, I don't know if there's a way for us to contact experts on the Sunshine Ordinance or those who have written the ordinance itself in order to determine, how they envisioned this particular process going. I'm a little curious about how much leeway we have as a task force to interpret the ordinance as we sort of see fit as well.
I think we have ultimate latitude to interpret the ordinance. We are, and it's with advice, obviously, but you know, in all the years that I've been on this task force, you know, when we get, we don't really have gotten actually direct advice per se, even through the previous legal memos that we've gotten from legal counsel. They aren't really, it's not really advice. It's a, you know, it's, we expect it to be advice, but it is a possibly a clear understanding and review of from a legal perspective as to what the complaint is and what the response is to the complaint. And instead of advice, just providing us with questions that we may ask so that we can come to our own conclusions. Our job, like if it was an en banc, you know, court, like a court of appeals or something like that, it's the independent understanding and interpretation of each of the judges. We're doing this, giving, and our charge is to give as great a weight as possible to public access. So keeping that in mind, how do you then interpret the law? Because there is a balancing test. The balancing test for us is, does it give more access to the public for public records? So I wouldn't worry about that. It's kind of like act as if until somebody complains. And it's kind of rare that does, except if it ends up in court and then it gets challenged.
So what are you proposing as the next step? Is this something that we should discuss with the full task force at the orientation part 2? I'm more of the mind that maybe we should come up with a recommendation for implementing this, as we've done with how we've adjusted how referrals. This is kind of in that camp of referrals. Okay, so and considering, you know, it deals with compliance of our order, it is definitely within our wheelhouse here in this committee. And I think it should, we should come up with some kind of recommendation. I mean, if you were to ask me, my interpretation is that whenever there is a violation in one of our order of determinations, that not only does it get posted, it gets sent to both parties and it gets posted to our website, but that it also gets sent to the Superior Court. As the Superior Court sees, you know, it could be just that there is in fact a violation. Maybe somebody in the court has some interest in taking up these issues. Maybe they have a case and they're like, you know, this is somewhat similar. And if the Sunshine Task Force in San Francisco is actually hearing lots of these kinds of cases, then, and they're being sent to them, you know, I don't know, maybe there's some there. I don't know. All I see is just another set of eyes looking at a violation. Right. Well, and I think we need to know who these are being sent to. Otherwise, this is like sending letters to Santa Claus to the post office. And they publish those online and people get to look at them and it's sort of this nice, you know, sweet thing at the holidays, but Santa Claus is not getting the letters. So I think we would need to identify a recipient. And I don't know if you have ideas for that or somebody who might be able to advise us.
Well, there is a kind of assigned or appointed, I don't know what they call it, the person that heads up the the superior, all the superior courts, all the divisions of superior courts. We got this certain word. I'm sure if Anonymous is still here, he will probably tell us what that is. But there is a person that is assigned to be like the face or the representative or the head or director of the superior, every division of the court system. So much like there is in the Supreme Court, there's I forgot what they call that position, that role. But Justice Roberts is that position right now. And that's who would be addressed to, and you're addressing it to the court and getting the attention of the person in charge, so to speak.
Shall I make a motion?
Sure.
Okay, I'm going to make a motion. I'm going to make a motion that we figure out who the person at the Superior Court is who we could and should send our orders of determination to. And once that person has been identified, that we add that to our process. And all orders of determination will be sent there. Second, we inform all parties when we make an order of determination that if documents, and not all of our orders of determination this won't apply to every single one, because some of them it's just a violation and things have already been, but if documents still need to be delivered, that they be delivered within 5 days, or there is some sort of agreed upon delivery schedule, and that they are sent to us as well, and then within 5 days or agreed upon schedule. And then the third piece is that petitioners will let us know if the documents are not responsive to the order of determination.
I'll second that with just some wordsmithing.
Please.
To reference 6721F.
Mm-hmm.
And I would also, this is more substantive, and see if you might agree to this, is that we pick some period of time retroactively to send our orders of determination.
Yes. I'm going to say, do you think we should send everything from 2020, or since this was kind of a fun year that we should go from 2019 forward, or, okay. So
I would say something like that. I mean, frankly, when you look at the kind of number of, I mean, I haven't counted how many there are, and orders of determination are, just a couple of pages. They're not that long. And actually could probably just put give them the link to the page and say, we're submitting to you all of our orders of determination going back as, part of the record, and ongoing, we will be sending, according to our voter approved law, we are going to be forwarding these items to the court moving forward. Or something
I
like that.
accept the amendment, and then I'm also thinking, since you annotated with 6721F, I also like to annotate the part about respondents delivering documents to the task force within 5 days under 6721E, just so that we're clear about why we are adding these clarifications in procedure.
Yeah.
Okay.
Yes, correct.
So we have a motion. We have a second, please. Yes?
No, you can take your vote first, but I just want to mention that we will need to update our complaint procedures and all our instructions regarding implementing this, just so it's clear to the public and everybody else.
Yeah, then let's also add that to the motion, that our any procedures shall be updated to reflect the motion.
I agree. So
is that enough, Victor?
We will bring it back. We'll create some drafts and bring it back for your review, because there'll be a little bit of wordsmithing involved, and we want to be sure we get your intent correct when we revise the instructions and the complaint procedures.
Okay, great. But when the task force approves this, if
Yes.
approves it,
Yes.
don't forget.
So are we saying pending the approval of the full task force?
Well, this is a recommendation for action to the full task force from the committee.
Yes.
That's what this is.
Okay.
So this motion is a recommendation for action from the committee to the full task force as outlined in the motion and the second. Cheryl, do you have a clear sense of the points that we've outlined here?
Well, I hate to say this, but I had to go let my friend in as soon as you guys started on the motion. I had to let her in. So I got the part where petitioners will let us know if documents are not responsive to the OD. Any procedure shall be updated to reflect the motion, recommendation for action from the committee to the task force. That's all and Bruce wanted to make a reference to 6721F. You are respondents delivering to the SOTF under 6721E so that we are clear about what has been received.
And so you got if you didn't get it, I think it should be clear on the audio.
I can get it from the tape.
Yeah.
I can get it from the tape.
And then if you have questions, will you ask us? I think it should be clear from the audio because we got pretty detailed with this.
Yeah, that's fine. That's fine. I'm sorry, I just had to let my friend in, so.
Should we open this up for public comment?
Yes, absolutely.
Is there any public comment on this?
Yes, please.
Just a second. Go ahead, sir.
Obviously, this is not legal advice to the task force. So I believe the person you want to address these to is the presiding judge. That would be the title you want to go to. And I'm really excited by this. I think this is really interesting. As someone of the many people who have come and talked to you at the full task force, we're very frustrated that nothing ever happens once we get orders of determination. This is a fantastic idea. I would say that the law, 6721E says, quote, upon the determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request, end quote. So I would urge you, from here on out, every single time you make a motion at the full task force, part of that motion is not just the violations, and you are ordered to provide these records. Because I have had arguments from the government that, well, they didn't say that you ordered it, even though it's in the law. So please always put that in any public records issue, not public meetings, but a public records issue, that they are ordered to comply. You did that in the last meeting, but I know I haven't gotten that always. And then the law says, quote, if the custodian refuses or fails to comply with any such order within 5 days, the Sunshine Task Force shall notify the district attorney or the attorney general, blah, blah, blah. So I think that it's not just ethics commission. If we come back here and it's been more than 5 days and you can't expand that time, it's in the law, it's not just your rule, and they haven't complied, you should always refer the matter to the district attorney. There has to be some consequences to this. Even if the district attorney doesn't want to do anything, you should do your part. And finally, about the Superior Court, I don't think you should just send them order the determination. What it says is the Superior Court shall have jurisdiction to order compliance. I think after the 5 days, when you come to compliance, and if you determine that there hasn't been compliance, then on that OD, you send a letter to the presiding judge says, here's the order of determination, please order compliance pursuant to 6721F. And they'll do whatever they want to do after that. They may ignore it. They might, who knows what they'll do. But I think that would actually start off this process, and you'd actually find out whether the court agrees you have this authority or not. Finally, please make the orders of determination, your motions, more specific, because they constitute the administrative record upon which those of us who want to sue have to sue. And when they're kind of more vague and the detail isn't in there, it's very hard it's kind of like the court will ignore what you said, and nobody wants that. We've all wasted our time if that's the case. So please do make your motions more specific if you can about why, say, a future calendar is public or whatever it is you're deciding. Because sometimes the task force does do that, which makes it a lot easier to enforce, and sometimes it doesn't.
20 seconds.
So I'd ask that you do make it. I'd ask that you do make them more specific in the future. Thank you very much.
Thank you. Members, do we have any comments or questions in response or any modifications to our motion and recommend on this recommendation to the full task force?
First of all, we ask if there was any other public comment because I see a second phone number.
Oh, I did not see a second phone number. Is there any, forgive me, is there any additional public comment on this matter? If you need to unmute yourself, it's *6. I'm not hearing any additional public comment, so
Okay.
Please proceed.
So I understand and agree with the public commenter on the 6721F part, that it shouldn't just be an automatic sending to or transmission or transmittal to the presiding judge, thank you for that, of the Superior Court, but only if there's a failure to comply, if they refuse or failure to comply. I mean, we have other areas which talks about refusals with regard to willful failure that goes to the Ethics Commission. I think a lot of things can happen all at once. And I also agree with the district attorney or the AG's office in general. We've only done that more as a referral than it's something automatic. But again, it's the same thing. If the custodian refuses or fails to comply within 5 days, I think 6721F just goes that extra mile, like what happens after. The problem with even the district attorney is really not interested in taking up our issues unless there's some criminal component to the violation. If there is, they just won't agree to take up anything civil. They consider it to be a civil case, administrative law to be civil. So, yeah, there's nothing much we can do about that. But still, sending it to them. The CPRA has lots of language in there for actually speaks to the district attorney being the first person to actually take action on something, like in the McKee Act that I brought up recently. The district, it basically says the district attorney or any person may bring this action, which is the McKee Act of providing a kind of an instantaneous injunction against a public body in violation of the Brown Act. So district attorney can do things. They just decide not to. Okay, so yeah, so I would adjust the 6721F part to be transmittals to be sent if there's a failure or non-compliance of the order of determination. That will just automatically default to the Compliance and Amendments Committee to make the decision and to then recommend to the task. I don't know. We can decide whether then it goes directly to the task force, or by virtue of our own rules that the CAC will just do it. Either way, the task force should be notified.
Notifying the task force, but then automatically sending it to the court. That would become a part of our procedure then.
Yes.
I accept that modification.
Okay. I'll work with Cheryl and Victor to make sure we can get it. We've kind of gone back and forth on a few things here, but it's a lot of it. It's a lot, but we'll get it right so it makes sense. So and thank you for the anonymous public commenter. Points very well taken. Thank you. I'm ready for a vote.
Okay. Member Wong, are ready for a vote? Cheryl, if you could please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion passes, and I will check the recording for accuracy in this motion. I'll send it to Victor. If he agrees with it, we'll forward it to Chair Wolf and to you. And then you can make your comments or edits or whatever you'd like to do for this specific thing. Hopefully I'll be able to get to this letter on Thursday or Friday. Okay?
Thank you. Thank you. Please call the next item.
Item number 11, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Members, please go ahead.
Yeah. Today's was a very kind of arcane day for a lot of these cases. They're very somewhat in the weeds for us, but more so since we're not. Some of these cases do not have legal memos attached to them. It's going to be pretty hard for the rest of the task force to kind of figure out what's going on and not have any guidance for it for some of these things. So I'm wondering if we might have to do some written kind of summaries on our own from what we've heard to the task force from this committee somehow. Kind of like how I asked for, can you give a brief synopsis of what this case is about? Something like that, just to kind of jumpstart everything from what if there was anything specific that the kind of at the complaint process needs to that wants the task force to know. I'm just a little concerned that some of this will get confusing to some people, and because it'll be the first time they've read about it, it's kind of like, where do you start, where do you end? Usually when we have a legal memo, everything's encapsulated, and I know at least for Anonymous, who does pretty good work and spends a lot of time obviously in setting these things up, it's hard for other cases that don't have the legal memos. So and things are just going to get more and more complex as the years go on. So I'm just thinking we do it on an ad hoc basis. If we think that there needs to be a little extra time, I'm not sure how to do that. It's kind of work product, and I don't think it necessarily demands a public meeting. But I think there could be some, we can, split it up, and everybody takes a case or whatever that, and then we can send it around just for wordsmithing purposes to make sure that's ready for prime time. What do you think?
I think that's a good idea. I'd like to ask whether you intend to hear all of these as a batch at one task force at one meeting, or if you think they're going to be split up just because we have stuff coming in from the complaint committee as well.
Don't know yet. I have to look at how our administrator is scheduling things out at this point. I mean, we're still slogging through, you know, what is old that is now being heard for the first time versus what is, you know, this year that hasn't been heard yet. And I had tried to get all the cases that had legal memos currently in them pushed up to the front first because we could get through those. And then possibly figure out it would provide us with a little extra time to figure out what's going to happen moving forward, which I still don't have an answer for yet.
Well, I think this is a good suggestion. I think it will help make things move along maybe a little more quickly with the full task force.
I'm going to suggest it to, you know, all the other committees that hear, you know, complaints also.
One thing that I think would be helpful is if we try, even if the hearings aren't going to happen for a couple of months, I think it would probably be easier for us to do it sooner rather than later. And would it be possible for us to be notified as soon as the audio is available from this meeting?
The audio will probably be available about 15 minutes after the meeting stops.
Oh, and on the website?
Not on the website. I have to send it to our IT person that does that.
Okay.
And I'll do that in the morning, or right after this meeting, whenever I get to hear the audio.
Yeah, Cheryl, that would be great. If you could let us know as soon as the audio's available for us, then we could get working on it soon while this is fresh in our minds.
Yeah.
Cheryl?
Yes, Victor.
When you send the email to IT, if you can include the members, that way they can get it sooner.
Yeah, I will.
Okay, then the question is, it looks like we have 1, 2, 3, 4, 5. Wait, is it just 1, 2, 3, 4, 5? Or was it 6? 1, 2,
Yeah, I think it's 5.
3, 4, 5.
What do you mean 1, 2, 3, 4, 5? What?
Oh, that there are 5 cases that we
anonymous cases tonight.
Yeah.
Yeah.
I'll take 2. And I guess if one of you wants to take 2 and one wants to take 1, you tell me what.
Yeah.
And I'll let you guys choose.
Who gets what cases?
Yeah.
What do I send? All right, Lila, you go first. What cases are you taking?
No, I'm going to go last. I will take the 2 remaining.
All right. Bruce?
Let's see, what do we got here? You're catching me on the spot. I'll take I'll take 7 and 8.
Okay.
File 20074 and 20110.
Okay.
Member Wong, do you have a favorite?
It does not matter to me.
Or you
Please
can
make
switch
a decision.
Then, you know what? Why don't I take 4 and 5, and will you take 6?
Sounds great.
Okay. Okay, and then I suppose once we've done these, let's share them with each other so that we can, I think, sort of get on the same page and make sure we think that we are conveying what the rest of the task force will need. Does that make sense?
Yeah.
Okay. Okay. Do we take public comment on this?
Yes.
Okay. Is there any public comment on this last item of discussion?
Yeah.
You'd like to make public comment? I thought I heard someone speaking.
Yes,
but I think
I'm just waiting for the timer.
Okay.
Notice.
Oh, I didn't know you wanted to start. All right, go ahead. Go ahead, sir.
So I would suggest when you're planning out, I would suggest when you're planning out the future schedule that I still think for fairness you should allow other people's complaints who are numbered in the 20,000s before you hear mine in the 20,000s. So I would still suggest that you hear 19124 and 19144, which are very old, and then maybe the rest of them come later, just to be fair to all the other people who have complaints. Thank you.
Is there any other public comment on this matter? I'm not hearing any other public comment. Just to make sure, if you need to unmute yourself, it's *6. Okay, I'm not hearing anything. Do we have any other announcements, comments, questions, or future agenda items from committee members?
Just a follow up on what the public commenter said is that it does, just because we're doing it in this way doesn't mean that those items will come sooner than later. I'm just invoking a practice. You know, obviously the older files will be, heard first, to give preference to them being the oldest ones. So just wanted to assure people of that.
Yeah, and I think our rush to do the write-up is to do the write-up while it's fresh on our minds, so that if it's several months when this comes up, we'll have those ready to go.
Yeah.
So
can I just make one comment?
Sure.
That's part of the staff notes that I prepare for the task force. And also CAC when there's a case to come back for reconsideration. Somebody hasn't gotten their records or something unsatisfactory about the way the situation was handled. So I just want to say that I do that,
and Cheryl, thank you. Those are appreciated and very helpful. I think there might be some value in having us also take a close look ourselves, so that we are, Bruce, are you still able to hear us?
Yeah.
Okay. I think there's value in us doing some of that ourselves as well, just so that we're better prepared to present in the full task force hearings. I think that was the intention here. Is that correct?
Yeah, I totally appreciate what's provided in the staff notes. It's just sometimes how we're trying to verbalize it out needs to be more succinct and more brief. And but it certainly will add to it. I think just in the way that the committee members have heard the case and feels that how the task force should be presented to the task force. That's the only reason why I bring it up, because of the lack of the legal memos that are provided. I'm finding that I have some things that to add beyond what are in the staff notes. So I just want to
Okay,
demand that we need. It needs to be some more. There's some more focus, and this is not a replacement for the legal memos that we've lost per se. This is still, even with those memos, if somebody didn't get an opportunity to read them for some reason, and just happened, and it wasn't prepared for a specific case, at least something is said verbally, and generally for the public also, because if there wasn't an understanding at the committee level, and then the one or the other or both parties then say, no, that's not what I was trying to explain at the committee hearing level, then it becomes clear. I mean, there are three parties in the room when it comes to hearing these files. There's each of the complainant, the respondent, and the task force. And everybody's got to be on the same page in one form or another. So that's my only concern about doing this.
Anyone have any other thoughts on this? And again, Cheryl, the staff memos are really the staff notes are helpful, and I think necessary for the task force as well. This is just another layer of information, and to help us do our presentations to them.
Okay. Yeah.
Yeah. I mean, further, I would just say, for some of these, like case law and sections of like the penal code, things like that. I mean, I would need somebody, who heard the case in the complaint committee to tell me how that applies, if I'm not getting it from our legal counsel. And it may not be enough in the way the presenter presented it for me to understand that. That's all. I don't want to have a college class in the middle of a meeting. I'm trying to understand some of these pretty arcane points, because we're not lawyers. All right, that's all I got.
Sorry, I was on mute. I said most of ours aren't lawyers. We do have a couple, but
yeah.
So I think we had public comment on this matter. I think we're resolved and we have a plan. Anything else, committee members? Or are we ready to wrap things up? I'm not hearing anything else. Cheryl, I think we're ready for the next item.
Item number 12, adjournment. Who moves?
Second.
Motion by member Wolf, seconded by member Wong.
Okay, I have 7:51.
Great. Thank you, everyone.
Thank you very much. I'll stop the recording.
Have a good week.
Happy holidays.
Happy holidays.
Same.
And New Year.
All right.
Take care. Thanks, Cheryl. Thanks.